Thank you for being here. For those who haven't come down already, please come and grab your complimentary book, Religious Liberty in a Polarized Age by Professor Tom Berg, who we're so fortunate to have with us today. Professor Berg is the James L. Oberstar Professor of Law and Public Policy at the University of St. Thomas School of Law in Minnesota. He teaches and writes on religious liberty, law and religion, constitutional law, and intellectual property. He also supervises students in the Religious Liberty Appellate Clinic, which files briefs in cases in the U.S. Supreme Court and appellate courts. And we have students and staff from our Religious Liberty Clinic here as well, so it'll be fun to collaborate and chat with Tom about some of the important work that he's doing. He's the author of 6 books, including, of course, Religious Freedom in a Polarized Age, a leading casebook, Religion and the Constitution, The State and Religion in a Nutshell, Patents on Life, Religious, Moral, and Social Aspects of Biotechnology and Intellectual Property. And he's written more than 150 scholarly and popular articles and scholarly book chapters. And his scholarship and advocacy have been cited frequently in opinions by the U.S. Supreme Court and other appellate courts. Tom has degrees from University of Chicago in both law and religion studies, from Oxford University in philosophy and politics as a Rhodes Scholar, and from Northwestern University in journalism. He's won awards for his religious liberty scholarship and advocacy from the Immigrant Law Center of Minnesota, DePaul University College of Law, the Association of Jesuit Colleges and Universities, and the Christian Legal Society. He's been co-director of St. Thomas Terence J. Murphy Institute for Catholic Thought, Law, and Public Policy, and he serves on advisory boards and projects for Church Law and Tax, the National Council of Churches, the Religious Freedom Institute, and a number of other organizations. About this book in particular, it comes at such an important time as our political and social landscapes polarize along party lines. Religious liberty is facing threats from both sides, from anti-discrimination commissions penalizing conservative Christians. On the other side, travel bans that are targeting Muslims. But religious liberty has historically been, and should be today, Professor Berg argues, a means of calming polarization and fear and anger. Drawing on constitutional law, history, and sociology, Professor Berg shows us how reaffirming religious freedom cultivates the good of individuals and society. And after explaining the features of polarization and the societal benefits of diverse religious practices, Professor Berg offers practical counsel on balancing religious freedom against other essential values in our society. Protecting Americans' ability to live according to their beliefs undergirds a healthy, pluralistic society, and this protection must extend to everyone, not just political allies. And Professor Berg has generously offered to sign your books afterwards. He'll linger around and answer questions. Once he's done giving some introductory remarks, I'm very lucky that we'll also be joined by Professor Rick Garnett and Professor Sherif Girgis, 2 fantastic professors here at the law school who also do law and religion work. And we'll have a conversation with Professor Berg about his book. Thank you for being here, and please join me in welcoming Professor Berg.
Thank you, Stephanie. It's so wonderful to be here. Always wonderful to come to Notre Dame, see many friends. I mean, the friends who are going to be up on the front here with me, Stephanie, Nicole Garnett. I see Bill Kelly. I see others here, and so it's great to be back. And I'm especially honored to come here because of what Notre Dame is doing in the Religious Liberty Initiative. This is a sort of spectacular leading force in protecting religious liberty in this country, around the world, religious liberty for all groups, and there's such leadership going on here. I was just struck by this when I was looking at the upcoming events on the calendar and saw that in 3 weeks the initiative is having a conference on religious freedom and the Black church. And I have a little section in the book on how about the ways in which African Americans have, although they in many ways have very strong interests in religious freedom that in many ways overlap with, say, white evangelicals and Catholics, there's a kind of has been a kind of pulling back from religious freedom advocacy, in part because it gets associated with political conservatism across the board, and resistance to racial justice, or resistance to affirmative action, or whatever. And whatever you think about those issues, it's bad for religious liberty to be associated with one side of the political spectrum. And that is just another example of it. And so I think it's fantastic what the initiative is doing in addressing those kinds of issues. So I'm just very, very happy to be here, and thankful for everyone's work in helping to make this possible. So I'm going to look down at my phone once in a while and scroll. That's not texting anyone in the middle of the talk. I'm going to just look at my notes a little bit. So here is the perspective that this book takes. Religious liberty is meant to prevent the human suffering that happens when people are penalized or otherwise forced to suffer for adhering to, living to their deepest beliefs about the divine, about the ultimate meaning of life, the purpose of life, and so on. And because religious practice is a perpetual feature of human nature, and because government is a perpetual element of human activity, these two perpetual forces are going to collide. They are going to come in conflict. The questions are perennial. So religious liberty is a perennial issue, but as I have been looking at it over the last, I think, dozen years or so particularly, I've come to be struck by the ways in which our current dynamics reproduce, I would say, in a softer version, thankfully a softer version, the kind of dynamic that made the adoption of religious liberty in the West, in Europe, and then America, a necessity in the first place. And that is the dynamic. This is not the only source of religious liberty, but the conflicts coming out of the Reformation and to some extent the French Revolution, but European conflicts that then got brought over to American shores and led the American framers to embrace principles of religious liberty in the Constitution, and then eventually extended in other ways in our laws. So what is that dynamic? During the Reformation, civil governments on the side of Protestantism imposed suffering upon Catholics, right? And civil governments on the side of Catholicism imposed suffering upon Protestants. And civil governments on the side of one Protestant group imposed suffering on other Protestant groups. And in England, in particular, it went back and forth, right, according to who was the monarch at any particular time. And in other words, there were cycles of fear, anger, and retaliation. Either retaliation for past suppression by the other side, or anticipatory suppression of the other side let's get them before they get us. Right? And those cycles led to, ultimately, in Europe, adoption of some sort of principle of religious freedom, little by little, incrementally. And it was the American framers responded to it ultimately by enacting religious freedom in the First Amendment. At that point, restricting only the new federal government from doing these kinds of things, but nevertheless enshrining that principle in the Constitution. So religious liberty was ultimately the solution, or a solution, to these cycles. James Madison, in his memorial and remonstrance against religious assessments, said, religious conflict is inherent in human nature. People will have differing opinions on religion. And governments have in the past tried to handle those disagreements by suppressing one side or the other. Torrents of blood have been spilt in the old world, he said, by the vain attempt of the secular arm to suppress difference in religious opinions. And every time, he says, the remedy for that disease has been to relax that suppression and enact what he called equal and complete liberty. Equal and complete liberty in matters of religion doesn't eradicate conflict, he said in the Memorial Remonstrance, but it sufficiently destroys its malignant influence on the health and prosperity of the state. And that is the kind of the insight or the theme that I think has relevance for today. We're in a softer version of the cycles of fear, anger, and retaliation, and religious liberty, I think, can again be a means not in the direct sense of preventing suffering, but also along with that, thereby at least countering to some extent the fear, resentment that come from that suffering and the impulse to retaliate. So what is the cycle today, right? It's part of the general polarization between progressives and conservatives. Religious liberty issues are a significant part of that. Progressives tend to view conservative religious believers as intolerant, as a threat to LGBTQ rights, as a threat to maybe racial progress, as a threat to the country, and therefore to fear and resent the influence of conservatism, and particularly religious conservatism. And then to try to forestall those effects by clamping down, by imposing, by adopting anti-discrimination laws, not just adopting anti-discrimination laws because I make a fairly strong case in the book for the importance of anti-discrimination laws, but refusing to recognize or resisting exemptions from those laws or protections from those laws to protect the religious freedom interests of religious organizations. Conservatives respond to that, or I don't know, were progressives responding to conservatives, or were conservatives responding to progressives? Who started the fight? I don't know. It's an interesting question, but it kind of doesn't matter because it's a cycle. Conservatives then are fearful. Conservatives are angry. The 2000 election was called the Flight 93 election. Remember that the ship of the airline of state was flying into the side of a building, and you had to do anything to stop Hillary Clinton. There were bases for those kinds of fears. One example that got a lot of play in even evangelical and I think maybe Catholic media as well, at the oral argument in the same-sex marriage case, Obergefell, Justice Alito asked the Solicitor General of the United States, if we recognize a right to same-sex marriage, will that mean the same thing for religious organizations opposed to same-sex marriage that racial equality laws meant for Bob Jones University, that Bob Jones University and other racist institutions lost their tax-exempt status? And the Solicitor General said, yeah, Justice Alito, that's going to be an issue. That got a lot of play in the election of 2016. That kind of consequence would have been very serious for the work done by Catholic and evangelical organizations. So, in response, The tendency is for religious conservatives to oppose anti-discrimination laws in general, LGBTQ laws, protection, and to take other steps. Maybe we need to, we need to get books out of the library. We need to take other steps in order to protect ourselves, and the cycle continues. So today I argue religious liberty can ameliorate that cycle. Right? You maybe don't need to undo the curriculum of LGBTQ affirming curriculum if you have some ability to opt out of it. You don't need to force the public schools to reflect your values if you have some ability to go to private schools and not be punished financially by losing government support for your education. I make these kinds of arguments in the book. So the argument of the book then is that protection of religious liberty can reduce polarization, calm it. I don't claim that it's going to, that it will deal with all of the issues. And I do think that religious liberty has to be argued for and has to be defined in certain ways in order to have that kind of effect. It needs to be strong first, or else it won't have the effect of calming people's fears and resentment. It needs to be equal for all faiths. One of the features of the cycle of violence in the Reformation was each side claimed freedom for itself. Said this is about the freedom of the church, or this is about the freedom of the individual Protestant to protest the church, right? And this is the freedom that matters, and the other side's freedom doesn't matter. The Puritans came to the United States to escape suppression in England and proceeded to suppress people themselves. So religious freedom, in order to really be religious freedom, has to be equal for all faiths. And third, it does have to acknowledge limits on that freedom, and limits in order to protect other important interests. So the first section of the book kind of diagnoses the problem the way I've diagnosed it now. The second section of the book makes a set of arguments for strong religious freedom, the kind of arguments that they're not the only arguments, but they're the kind of arguments that I think have the most potential to cut across ideological lines and therefore create at least some, not a consensus, but some increased bipartisan support for strong religious freedom. And the third section of the book is about the limits and the other interests. Very briefly, we can talk much more in the discussion about the kinds of limits. When I say religious freedom has to be strong, but it also has to be limited, that's like, okay, that means the devil is in the details, isn't it, right? And that's what the last part of the book is about. I'm happy to say quite a bit more about that, but in the area of LGBTQ rights and religious freedom, I've essentially said two things in my work over the years, and I argue them in the book as well. Number one is that we ought to enact non-discrimination laws where they don't exist with religious exemptions, right? So we ought to protect both sides by having both protections against discrimination and significant religious exemptions to take account of the religious freedom interest. That means I filed briefs in support of the same-sex couples in the Obergefell case, and also in support of Jack Phillips, the cake designer in the Masterpiece Cake Shop case. I think there were 3 lawyers in the country who filed briefs on behalf of those two plaintiffs, and I'm one of them. I don't know what being one of 3 lawyers in the country means. It might just mean that you're out to lunch, but that's kind of protecting both sides is my goal there. And the second aspect of it is defining what the limits should be. So if we look at the area of LGBTQ rights and religious freedom, I develop a set of arguments why the protection for nonprofit religious organizations should be very strong, and the various grounds for that, and why protection for the commercial entity, the small business who provides ordinary goods and services, wedding services, and so on, the website designer, the cake designer, the florist, et cetera, why those protections should exist, but they have to be much narrower and more carefully defined. And we can talk about the details on that. I will leave it there and really look forward to talking with Rick and Sherif.
Tom, thanks for that really excellent presentation, and thanks again for writing such an important book at this moment. One thing that really struck me was how you identified some of the ways in which our country is continuing to polarize, and in particular, I thought the perception gap was something really interesting that you talked about, and the way that the loss of mediating institutions, including religious groups, contributes to that. Can you speak a little bit more to that increase in the issue of the perception gap and how losing the rise of the nuns contributes to that? And then, Rick and Sherif, do you want to ask a question now, or do you want to wait? Okay, we'll go down the line and let you guys ask questions.
A huge part of the polarization, as I'm sure you've heard over and over again, is that we not only disagree on interpretation of the fact, but we disagree on what the facts are from varying news sources and so on, and that makes it especially difficult. It's kind of a depressing book to write because the first chapters are about what's the depth of our polarization. So you're reading one social science book after another talking about advanced stages of polarization and rotting out of the body politic and that sort of thing. And one writer says that when you've got fundamentally dueling fact perceptions, you have an advanced stage of polarization, and it's very hard to come back from that. Just to take this in a little bit of a maybe slightly different direction. Who's more at fault for the dueling fact perceptions? In the book, I try to resist making an argument about who's more at fault, and that's not because I think there's no truth to be had, that there aren't ways in which one set of fact perceptions that you get on one cable news show or network better or more accurate than on another. But it's because there's a tendency for all of us, even if our view is often right, there's a tendency for us to overstate how right our view is and to overstate the wrongness of the other side. That is a feature of human nature. It is a feature of, to speak in theological terms, human sin and pride. And so the point that I try to make in the book is that I'm not making an argument for both sidesism. Whenever you say, well, the left and the right both have responsibility, somebody says, oh, both sidesism. You can't do that. There's too much at stake here to just equate the two sides. And you hear that from conservatives and you hear it from progressives, obviously. I don't believe in both sidesism, but I do believe that there are particular issues on which we can say this position is more in line with the facts. And then watch out that the fact that your side is right on this, don't assume your righteousness on some other issue. I think that speaks to conservatives. I think that speaks to progressives who, whatever advantages they have on other issues are just as responsible for the religious liberty problems that we have as conservatives are.
Tom, I wanted to make what I think is a friendly amendment, just observation, because we've known each other for a good billion years. And then I wanted to ask a question about kind of doctrine and operationalizing your devils in the details point. So the first thing is, you emphasized in your presentation and in the book what we might call the kind of the negative case for religious liberty, by which I mean you talked about religious liberty is an important way to prevent human suffering, right? You talked about it as a way of managing the reality, at least to this side of heaven, the reality of deep difference, disagreement, pluralism, and so on. The kind of the Madisonian argument, and that's all true in my view. But I take it you'd also agree with maybe more of a positive case for it, which for me is what's animating the Second Vatican Council's Declaration on Religious Freedom, which would be that human beings, by virtue of being human, precisely because they are persons, precisely because they've been given dignity by God, they have an affirmative positive right to religious freedom. Even if everybody agreed, that would still be true about human nature. And relatedly, that religious communities have an affirmative positive right to govern themselves. Again, not just as a way of filling out the space of civil society, which is nice, but that there is a right grounded in dignity that places affirmative jurisdictional limits on the government. If you disagree with me, obviously feel free to say, but I suspect we're on the same page there.
I'm staying silent, so
the question,
you can infer from that.
Fair enough. The question has to do, again, devil's in the details. We got a bunch of first-year law students here and some others. We're learning about doctrine and how you construct doctrine that serves its purpose as well. If you're trying to put together a legal regime that's going to identify those cases where religious exemptions are appropriate and distinguish those cases from situations where religious exemptions are not appropriate, you're going to have some tests, right? And you have a very sort of erratic and reasonable way of balancing concerns, but courts are going to have to apply rules. And so I wonder what you think are the variables or the criteria that you could tell a trial court judge, this is what you need to consider when you're trying to decide whether in a particular case an exemption is warranted. So for example, should a trial judge be able to ask whether a claimant is sincere? Should a trial judge be able to ask whether a claimant's views are actually religious or whether they're merely philosophical? Should a trial judge be able to ask, you see where I'm going, I know, whether the government action is burdening the core of the religion, the central tenets, or is it enough that the claimant says, I have a religious motivation? How do you put that in the doctrinal, how do you construct the rules to take care of those details?
Yeah, you go right to the devil in the details.
That's what I hear a lot.
Those are you go straight to the devil. So the structure of a free exercise case is usually what's the burden on the religious claimant on the one side, the first question. And then what is the government's reason for imposing that burden, and does it meet the standard of compelling interest or important interest or whatever the various, I don't know what else I've got in constitutional law yet, and that's not a first semester course. So, but at any rate, those are the standards. So Rick, you're asking primarily about the first side of it, but maybe you're asking about the second side too. And the first side of religion cases has been a problem for courts because there are features of religion that make it harder to assess than other kinds of rights. Who's to say whether this restriction, whether the mandate to cover contraception by paying into a pool of insurance money that then might be general pool that might be used in some cases to cover contraception, et cetera, whether that's in conflict with your belief. Well, it's got to be left to the individual to decide that within a broad range. And who's to say what's sincere? Many of the tests that we give for sincerity and individual sincerity depend on inferences about reasonableness. Your position is so crazy, you can't really mean that, right? You can't really sincerely believe that. Or, you said the opposite thing a year ago, so you must be insincere. But there's a thing called religious conversion, right? And so you raise very good questions. I do think the courts have to be able to make some cuts at the early stage. I think there should be some ability to question sincerity. There is a lively debate going on now in the law reviews about how much courts should be able to question sincerity. The general rule has been very little, and some scholars are arguing for do that more because otherwise we're letting in all sorts of crazy things. One feature, you got to read the whole book to see all of the features that I think are important. But one feature we can, I think in a broad sense, differentiate or draw some lines between cases where a religious exemption claim coincides strongly with secular self-interest, and cases where it doesn't coincide strongly with secular self-interest. So let's take a couple of examples. Tax exemptions, right? In general, the law has been negative on giving special exemptions from taxes to religious organizations. There are tax exemptions for nonprofits, right? But religious organizations don't have a special exemption. When they do, there are a few limited exemptions, limited special protections for churches, but they're only limited protections. They're like extra procedural protections, and the IRS gets to look very closely at what constitutes a church. We allow the IRS to do a lot of that. And that's because I think there's a sense that a lot of people want to avoid paying taxes and will, if it's too easy, will shelter themselves under the claim of religion or under the claim of a church. On the other hand, there are a great many religious norms that don't make strong sense to the non-believer, and that people will not sort of draw a lot of people to make those claims. I think that's probably the more common situation. And that affects the first side and the second side of the equation, right? Are you more likely to be sincere? You're more likely to be sincere if it doesn't coincide with secular self-interest. And the government's interest is likely to be stronger if it does coincide with secular self-interest, right? Because a lot of people may make those claims. That's only one sort of factor, but it's at least something of an answer to what you're raising.
So I really enjoyed the book, but I had a bit of an issue, which is I think of it as having two halves. One is a diagnosis of the problem, and the other is a prescription. But I was so convinced by the diagnosis that I was worried the problem you identified would prevent us from getting to the prescription. So I'll ask you that in two ways. So one is, you say that strengthening religious liberty could reduce polarization. But you also point out that polarization is an obstacle to strengthening religious liberty. Partly because religious liberty and religion have been caught up in the polarization that's affected everything else. So it makes it seem like a chicken and egg problem. We've got to overcome our polarization to expand religious liberty and use it as a way to overcome polarization. So it could sound like a gotcha question, but I actually really sincerely mean it. What are there particular, if you were czar over all the religious liberty advocates in the country, is there a particular next religious liberty battle, legislatively or judicially or something, that you think would be a nice, the head of the spear to advance religion despite our polarization? And the second part of that, for me, was what you described as the rise of the nones, N-O-N-E-S, the people who are not religiously affiliated, because it's pretty natural to think you'll support religious liberty if you think religion is valuable. And you're likelier to think religion is valuable if you are yourself religious. So the fact that there's a huge increase in the number of people who do not identify as religious means that it'll be harder to get people to see why religious liberty is worth what you acknowledge are the costs of protecting it. And in fact, this exacerbates the first problem because, as you also point out, religious disaffiliation is itself a very politically divided thing. I think you said this is one of the stats that surprised me. 38% of self-described liberals identify as not being 38% identify as not being religiously affiliated, but only 11% of conservatives. So, how do we break through this circle?
Yeah. Great. You're supposed to ask easy questions.
You bought your Chick-fil-A, you get part of it.
Chick-fil-A. So, on the first question, I think the most, so we need incremental steps, right? We need baby steps. You need small victories if you're gonna make progress on these kinds of problems in general, whether it's religious liberty or whatever. You need to find small things that people can agree on, and there are individual cases that have gathered coalitions of conservative and progressive groups. Right? One of them is one that Stephanie Barclay argued in the Ninth Circuit. How many months? 2 or 3 months ago, something like that.
March.
Yeah, in March. Yeah. The effort of Apache groups to prevent the destruction of the sacred site called Oak Flat in Arizona, a place for use of that they've used for rituals for hundreds of years, that is threatened to be destroyed by the transfer of the land to a copper company to do a mine that will blow out something like a 1.5 mile long crater and destroy the vast majority of the sites. There were groups across the spectrum supporting the Native Americans in that case. We've seen, despite the, I would say, sort of xenophobic resistance to Muslim claims among some white evangelicals, we've seen evangelical groups and Catholic groups support Muslim claims, support the ability to build a mosque, even if the community doesn't want it. So I think the cases where there's a kind of classic religious minority can bring people together, and conservatives are coming to the party, so to speak, on that as a realization that the principles that apply in those cases will also apply in other cases. Well, I guess that's a pragmatic argument, but it's also an argument of principle, and to add to the principled argument, Rick, that you articulated, it is the argument that freedom to pursue a relationship with God, or more abstractly, the divine, is affirmed in our faiths. Right? It's affirmed in Vatican II. It's affirmed in evangelical faith. If you read the work of Russell Moore, the Southern Baptist leader, who's been a real leader on this too, he makes kind of a full religious argument for religious freedom. I didn't make those arguments in the book as much because, and I'll just say very briefly, I would characterize this book in a way as a book of apologetics. Apologetics, right, is the religious writing that attempts to argue or explain or defend the propositions of the faith to those who are skeptical but open to persuasion, right? And this is kind of an apologetic for religious freedom. It doesn't make every argument. I've tried to make the arguments that I think are most likely to appeal across lines. So, okay, so I got away from your second question, true, that I'm going on here, but it's essential. Religious freedom will handle the clashes between Muslims and evangelical Christians because they can unify around a principle of religious freedom. It won't handle clashes between atheists and believers, and it won't handle clashes that involve, say, sexual equality or sexual minorities and religious believers. As to atheists and religious believers, I think we need a strong establishment clause as well as a strong free exercise clause. The last chapter of the book is critical of the current court and supportive of the current court for its strong commitment to free exercise, critical of it for its retreat from stronger principles of non-establishment, particularly the cases about government, religious symbols, 10 commandments in the schools, 10 commandments in the courthouse, etc. I think that those are impositions on atheists, and the court ought to protect them, protect atheists against that. And then as to the other source of division, LGBTQ rights and religious freedom, we need to protect LGBTQ rights as well as religious freedom. The book includes an extended analogy that I've been talking for several years about the interests of same-sex couples and the interests of religious objectors and the parallels between them. Both groups, the role of these claims in their lives have some similarities, and that those parallels, I argue, should lead us to have some sympathy and protect both sides. So I'll stop there.
Yeah, I want to pick up on that point because I thought you were addressing one of the most important debates that's happening right now, which is one of the many, that religious objections to conduct requirements surrounding human sexuality are often compared in the media or legal briefing to racial discrimination. And you make the point that that's the wrong analogy. Really the closer parallel between LGBTQ identity is religious identity. And we prohibit religious discrimination generally, but we provide exemptions for that. We think about that a little bit differently. So can you build on that idea a little bit more? I'd be interested to hear from Rick and Sherif if you agreed that that's the better way we should be thinking about that analogy, because that's one that, in Fulton, in so many of these other cases that the advocates are talking about, they're being asked hypotheticals about what do we do about the race analogy.
I think racial discrimination has been treated in our law as not the only wrong form of discrimination, but uniquely wrong. And there are various indications of that. One, for example, is in Title VII, there's something called the bona fide occupational qualification defense. When a business is sued for discrimination, they can say the feature here is a bona fide qualification for the job. And they can make that as to a claim of sex discrimination, they can make that as to a claim of sexual orientation discrimination, etc. Can't make it as to a claim of racial discrimination. And there are multiple other ways in which we don't allow exemptions for racial discrimination, period. Whereas we historically have allowed other exemptions for other forms of discrimination. That reflects, I think, a couple of things about race discrimination that mean we don't have to treat sexual orientation discrimination exactly the same. Number one is just the pervasive and fundamental harm that racial discrimination has been in our history, right? The original sin, the cause of a civil war, the continued basis for broad oppression in many parts of the country for years after that civil war. So that's a historical point about the kind of the uniqueness of racial discrimination. The other is really a more conceptual point, and that's what you're referring to. Same-sex discrimination is more like religious discrimination, I argue, because what we're talking about when marriage is denied or there's discrimination for being in a same-sex partnership, you're talking about an identity there that is important to the person, that is bound up in conduct, though. It's not just the identity, right? Folks are not discriminated against purely because they say they're gay or lesbian. They're discriminated against because they're in a relationship that reflects that. And, okay, but the courts say, yeah, but that conduct is so closely tied to the identity that you can't separate them. Yeah, but that's true about religion as well. And so, some liberal courts, and the court did this in a case called Christian Legal Society versus Martinez, a wrongly decided case, emphasized how much identity and conduct are bound up for LGBTQ folks and for same-sex couples, and then turned around and said, a religious group that objects to LGBTQ equality can be excluded from meeting on public university grounds. And you know why? That's because that rule that excludes them doesn't go after their beliefs or their identity. It goes after their conduct. Two different things, right? And the court said that basically unironically, having just equated identity and conduct in the first context and then denied it in the second. I think it's true in both. That's part of the parallels. And both groups also want to be able to live out that conduct, that identity-based conduct in public, not just in the closet, so to speak. For the religious believer, that's right. Not just in your home. You don't have to keep it in your home. You don't have to keep it in your worship service. You can live it presumptively in your nonprofit work, your social service work, your educational work, and in the workplace, subject to limits that there have to be. But it's that parallel that makes me think it's a better analogy than racial discrimination, which is race is just a feature, right? It's not a conduct. It's not this complicated mix of identity and conduct. It is just simply a feature about people, and that's makes it, I think kind of the hierarchy makes it more constitutionally objectionable.
Well, I actually had a question about this compromise between, so on the one hand, protecting against discrimination based on sexual orientation, but also allowing exemptions that are rooted in religious objections. And there's a certain kind of critique of this. So you propose this both as the solution to our polarization on these issues, that's such a huge source of polarization on religious liberty, but also as a kind of sensible ideal and as a stable and sensible ideal to aim for. But there's a critique of that from the left, which is that it's actually a destabilizing ideal, because which takes one of two forms. One is by allowing the objections based on religion, you're allowing exactly the kinds of harms that anti-discrimination laws are supposed to fight. Or second, and this is the point that my old teacher Rita Siegel and her co-author Doug and Jamie make in an article that you discussed briefly in the book, that the religious claimants are using their exemptions partly as a way of resisting and arguing against the very anti-discrimination laws or same-sex marriage laws or so on that you're saying should be part of the stable ideal. So, and you've got an answer to that, and I thought it'd be helpful to bring it up.
That argument, they're using their freedom to resist us, is first of all, it's a rejection of Madison's point, right? The argument in the memorial and remonstrance, and I take that document as a great statement of principles of American religious freedom, is that the conflict and the disagreement can continue to go on. And the way it is controlled and the way you keep it from becoming a cycle that spins out of control in fear and anger and resentment is by letting it go on in the private space. And so this will empower them to keep going after us is exactly the dynamic that led to the cycle of violence, and we have to avoid it. Now, I mean, the other thing is that people assert religious freedom not just in order to be able to live some private life off in a corner, right? The civil rights movement asserted religious freedom to be able to march and to be able to promote justice and attack injustice. And so a principle that says you're only free when you want to be able to go off in the corner would not fit with a lot of other examples of wonderful phrase by Jacqueline Rivers, who is a sociologist at Harvard, studies the black church, enacted religious freedom. The civil rights movement, they were not so much asserting religious freedom as just living it. They were out there religiously motivated, preaching and demonstrating and living it out, enacting it. And that is, that's central to it. There's no idea that you give up your right to be engaged in political debate as the price of having your religious freedom.
This is a little bit of a different point, Tom, very much a different point actually, but like Sherif, channeling some other people in our business, I know you've heard this before, but a lot of, maybe ironically, a lot of law and religion professors these days are asking, what's so special about religion? And that might seem like it's not in their best interest to question the relevance of the thing they purport to study, but let's put that aside. Why can't your book just be called Liberty in a Polarized Age? That is, religion's important to some people, not everybody. The Boston Red Sox are important to a lot of people. Environmental stewardship is important to a lot of people. Go down the list, right? What's special about religion? Lots of other things are important to people's identity too, right? So besides the just textual fact that religion is mentioned in the First Amendment, what's the reason you would give to those who say there's no justification for providing special protections for religious objectors when we don't give them to people who just don't feel like complying?
So the basic answer, I think, to that is I'm in sympathy with the folks who have said in one way or another, if that's true, it doesn't mean don't protect religion. It means protect other things as well. There are other forms of identity that are important. The Red Sox, probably not. Maybe the Cubs, but you know, but serious moral views. You know, there's in the book I argue that there's some room to define religion broadly to encompass other kinds of comprehensive views that may not only serve this function of organizing the individual's life, but also make a kind of comprehensive statement about life. So that's one possible way of protecting other things as well as religion. But the other is that there are other constitutional rights. Right? And for example, there are marriage rights, and there are personal family rights, and the protection, you know, Bergefell and other decisions is protect other things. Professor Andy Koppelman at Northwestern, I agree with a point that he says, which is, you know, you protect these important things in human activity one thing at a time because they each have their own logic and arguments for them. It's very hard to speak in the abstract about all important things and try to develop a sort of doctrine of protection for everything that might be important to someone. Let's protect religious liberty. Let's protect other things as well, but not undo religious liberty because we haven't succeeded in protecting everything else forward.
Just a quick follow-up.
Yeah.
As you know, it's been argued that a risk here is that if we try to expand the kinds of requests and commitments that can give rise to judicially created exemptions, then it's just as sure as the sun rises, courts are going to provide less protection. That is, they're going to make it harder to get exemptions because you simply can't operate a political community if everybody gets exemptions and gets strict scrutiny of burdens on their on things they care about.
Yeah. I think that's right. And so I only would expand the concept of religion a bit. There's at the risk of getting textual here, I do think that text arguments are worth making. There's a nice feature in the First Amendment that should keep you honest. Whatever argument you're making, it should keep you honest. And that is the very same thing that the First Amendment protects the free exercise of. I'm sorry, I'm ending with a preposition now. It also prevents the establishment of. So if we expand it too broadly on the free exercise side, and anything counts as a religion, then anything also counts as a religion for establishment purposes, and the government won't be able to do anything, right? So I think the expansion of the concept of religion can only go so far. I've got an amount that I feel comfortable with, and I don't think it's going to cause the kind of problems that you are referring to and that others refer to. But it can only go so far.
On this point, you do spend some time in the book also talking about how part of why you're arguing for more robust religious exemptions is to bring them in line with other constitutional rights, like freedom of speech, and how we would provide, as applied exemptions there. So maybe speak to that a little bit, Tom. And you also talk about one reason why protecting religious exercise is valuable for society, even the atheists who we were touching on earlier, and we're talking about this on page 151, but it's because of the service that a lot of religious groups contribute. So even if you were a person of no faith at all, we should be worried if government is doing things like closing down soup kitchens and hospitals and homeless centers, and that there's the book American Grace, written by a number of authors, one of whom is a professor here, that talks about how as religiosity for people goes up, it's empirically tied with their secular contribution to society, and that's a good thing for everybody. So maybe speak to both of those issues briefly.
Sure, great. And Stephanie has written about this. We have used over the years the term exemptions to describe the protection of religious freedom in the face of a generally applicable law, a non-discrimination law or a drug law or whatever. And exemptions, maybe we shouldn't be using that word. Maybe it sounds like special break, etc., right? And maybe it was rhetorically bad strategy to use that. What Stephanie and others have pointed out is that what we're really talking about is that the law restricts or burdens or prohibits the fundamental right in a particular application, in a particular case. It doesn't do it on the face of it. It doesn't say you can't use drugs if you use them religiously, or you can't discriminate if your reason is religious, but it still imposes on the religious right in application. And that's true in other First Amendment rights too. In fact, as the court has said often, as applied challenges, let's get constitutionally nerdy here for a minute, as applied challenges are the preferred form of constitutional challenge versus facial challenges to the entire statute, right? We should have come across this sometime in constitutional law, maybe. Should we strike down this whole statute because some of the applications of it are constitutionally invalid? No, the courts say we got to preserve the statute as much as possible and only strike down those applications that violate the right. And that's what so-called exemptions are. So maybe a better way of framing it, certainly a true way of assessing it. Very briefly on the point about religion and the common good, there's a chapter on religious freedom, or an arguments for religious freedom based on its contributions to the common good. And it includes a lot of the kind of evidence that Stephanie mentioned about the service that religious organizations provide. I think, for example, that the Catholic bishops are absolutely right to brand their religious freedom campaign under the title Freedom to Serve. Because very often what's going on here is organizations want to be able to serve people and do it consistent with the beliefs that inspire the organization in the first place. I wrote that, I've been doing that kind of argument for a few years, and then wrote it up in the chapter with some temerity. Is that too much of a big $5 word? A little bit of concern, like, should we make religious freedom dependent on whether it contributes to the common good or not? And so I try to work out in the chapter about how we can make that argument but not have religious freedom be dependent on somebody's assessment of whether you're contributing to the common good or not. And you can, as you read it, you can see whether I've squared that circle well enough. But it is very true that there's tremendous social science evidence that increased, and it's not just religiosity, it is active involvement in a religious community leads to higher levels of volunteerism, higher levels of donation, and not just donation and volunteering to religious causes. People who are deeply involved in a parish don't just do more parish work, they also do more other kinds of volunteering work. But it is about the active involvement, not just stating a religious view. And that fits with a lot of other social science evidence that tells us that the deeply religious, those who are deeply involved in a congregation or in a community, not only serve others, they're also happier. And people who have maybe left religion behind are happier too. Maybe they're not, they found other ways to be happy. It's the kind of lightly religious, the ones who keep the kind of form of religion but aren't actively involved. Their happiness numbers are going down and their service numbers go down. So it's the social science is really interesting, and I talk about some of this in the book. But implications, restrictions on worship, in-person worship during COVID, strike at one of the things that religious freedom really brings, which is bringing people together in congregations, in contact with each other. We know that fits with the fact that we see increased depression and isolation and so on as a result of the kind of isolation that people have had. And I'm not attacking the shutdown orders, but they did impose a serious burden, and eventually the court started saying, you've got to be very precise with these, and I think they were right to do that eventually.
Well, there's so much more that we can discuss, and wish we could. I'm sure students will have questions and want to come down and meet with Professor Berg, have him sign your book, but let's all give him a warm thank you for sharing. Thanks for the great questions.